Go ahead.
All right, well, welcome everyone to our webinar here today. Thanks for joining us this morning. We're really happy to have you all here. Today's webinar is Will Contests and Spousal Elections, How to Prevent Mistrust and Disaster. So basically the idea here that we're gonna go through is potential issues that you may have with heirs and beneficiaries or people left out that could create issues in your trust planning after you pass away, including potential spouses that feel like they didn't get a fair shake from whatever's being left to them, the potential issues that can arise, but also some practical planning tips, right, in order to figure out how to prevent these things from happening, right? So let's get into it. Just we have a first page here. So me and Toledo, we're both co-heads of the Trust and Estates Department. We have Chase Perlowitz Luftig, and we deal in both domestic and international cross-border estate planning and tax questions. I tend to focus more on the domestic side of things. Toledo tends to focus a little more on the international side of things. We both do it. We're both licensed in the state of New York. I'm also licensed in Florida and New Jersey. Toledo's also licensed in Brazil. So we've got several states and a couple of countries that are covered. And here, this is really just for contact information. If you guys have any questions you might think of after the presentation, feel free to shoot us an email. We'll be happy to answer anything you may have. Any questions that you have during this presentation, feel free to just put it in, I think Oliver's, should it be the Q&A or the chat box? I think we've got two things here. We're going to go through the presentation first, then at the very end, we'll go through your questions and give you your answers to that. So let's dive in. First thing, I always like to do this. I did this for another presentation. I think this is a great quote. I got it from another attorney years ago who got it from another attorney. He probably got it from another attorney. So, and this is something that we tell all of our clients. Everyone has an estate plan, either one created by themselves or one created by the state. What that basically means is if you pass away without a will, trust, whatever it may be, any sort of planning, well, wherever you're domiciled, if you're here in New York, then New York already has a plan for you. It's called intestacy rules. And it's basically the state's best guess at what they think you would have wanted. Rarely is it the case that the intestacy rules get it right, and it usually does lead to a lot of confusion, heartache, and also very upset family members. So we always stress it's better to engage counsel, look into an estate plan, and make sure that you're the one making those decisions and that you're going to have the right people in the right places to carry out your wishes. So very quickly, importance of an estate plan for everyone, right? So this isn't just, I just wanted to pick up on this because this isn't just an estate plan if you think you're going to have, if you're rich, or if you think you're going to have a disgruntled child that's going to cause issues in the future, or problematic spouse. It's for everyone. It ensures individuals' planning objectives are accomplished, right? That the right people inherit the right assets. Very, very important as well, though, is a good estate plan also covers potential issues during your lifetime, not just death, right? That's a common misconception. You have to have a decent durable power of attorney, healthcare properties in place. Those are essentially you picking your agents who would make these critical financial and healthcare decisions during your lifetime. And why do you want those? Because if you don't have those in place, whoever is looking after you may need to go to surrogate's court for that, and a judge might end up someone that you wouldn't necessarily want to make those decisions, right? And it can also, if you have creditor issues, if you're a business owner, if you're in a high-risk job, surgeon, lawyer, then it can also encompass succession planning, both asset protection as well. And a few other points: it limits discord between family members, right? If you really give it some thought and understand where things are going, you can really, really try to limit any sort of discord between your family members, friends, and all that stuff. And Also, if you've got very, very significantly high assets, and we're talking here like at the very least $6 million, right? At the very least, then it's got the potential to decrease or eliminate any potential estate taxes or any income taxation on built-in appreciation. So let's, I just wanted to go first. I don't want this to get too technical, too complicated. This isn't a continuing learning education. This isn't meant to be a presentation for lawyers, but I do want to just touch upon a few things, a few background things that would probably make things a little more understandable as we go along this presentation. And the first point is capacity to make will, trust, or power of attorney. All right, it's important for everyone to know just, well, you know, who can actually do it? If you're on your deathbed, if you're going senile, can someone even do it? So mental capacity, there are three basic different thresholds. I mean, there's really, I put three there, but there's really just two. Last will and testament, believe it or not, is the lowest legal threshold you could possibly have for mental capacity to make a document lower than a contract, lower than any other document, right? It's basically the person signing the will, which is called the testator, has just have a very basic understanding of its terms, know what we call the natural objects of his bounty. For instance, if he has children and a wife, then he should be able to recognize them, understand who they are. He doesn't necessarily have to give it to them, but you know, if you've got someone on their deathbed and they're going in and out of consciousness and they think that their children and wife who are standing there passed away like 10 years ago and they want to leave everything for their dog, then yeah, you're going to have an issue there in terms of mental capacity, right? So, but at the same time, you can have people that are very sick on their deathbed and they are going through these moments, but they can have what we call a lucid moment, right? A lucid moment when they do understand things. I mean, this does happen, especially when people are on medication. If they're in a lucid moment, then you could have them sign their last will and testament, and it could be considered valid. It could be considered to have the mental capacity for it. Also, they should know what they actually own, right? I mean, if they own $10 million, they have $10 million, and they think they only have $10,000 in assets, and they want to leave it to some complete stranger, right? Then that could be potentially an issue as well. The capacity, the mental capacity for either a living trust, durable power of attorney, healthcare proxy is actually a higher standard. That's more similar to a capacity that you have for a contract. So they can't, you know, what can end up happening is if you have someone during that lucid moment that signs all these documents, like a will and a trust and a healthcare proxy, it could be that later on down the road, like a healthcare proxy could be considered invalid, but after their death, the will could actually be considered valid, despite the fact they signed it all at the same time. So this is another crucial, important key why it's important to get estate planning done well ahead of time, when you're still healthy, when you still have your mental capacity, because then things start getting very, very tricky, right? We have to start asking difficult questions. We have to start deciding on, oh, well, you know, are we going to do a will and a trust? You know, a trust might be more preferential, but a living trust, for instance, but that might not necessarily work here. Although a very, very interesting differentiation is a living trust could be like a contract. You can actually put what's called a testamentary trust into the will. And so that's a bit of a backdoor way to get it. But again, they do have to have some sort of recognition of where these funds and where this money is going to. When you have trusts, you're going to start having more probably more complex instructions for the trustee, and that in itself could be potentially considered invalid. So always go make sure this planning begins well ahead of time. So let's just dive in for grounds for will contests, right? I mean, we hear about this all the time. It's pop culture, you know, the kind of cases such as you know, the very young wife that marries a very elderly, rich millionaire, billionaire, and then he passes away soon after they marry, and she leaves everything to her. That's the classic example. And then a fight starts with kids and all that kind of stuff. So what is it exactly that they use in order to try to challenge a will? And there are basically three different grounds for a will contest, right? There could be more, but these are the main grounds, right? So, and we're just going to focus on New York law here right now. So, three main grounds. The first is due execution. Second is lack of testamentary capacity. So we kind of touched upon that just before about mental capacity. And three is undue influence, right? These are the three most common ways in which a last will and testament that's presented to the court for probate is challenged.
And actually, Chris, I think
Yeah.
for these three ones that you just mentioned, I think the due execution is the biggest one. So that's why it's very important to have an attorney advising you when preparing your will, or even like, subsequent amendments, the revocation of a previous will, because this is a big one for a will contest.
Yeah,
so
absolutely. You're absolutely right. I absolutely agree. Due execution, that's what is it? It's the formalities, right? It's like what you put the document together. Okay, now you need two witnesses. They all need to be in the same room. The person has to at least say what the document is that they're signing. The witnesses have to understand that they're signing a last will and testament. And not to mention that if there's any issue with mental capacity, it might be good to make a videotape of it, or videotape. I mean, make a cell phone video, I guess, these days. I'm dating myself here. But yeah, it's like pretty much every state has some sort of formal requirements, and they're strictly construed. And it's really the most common way in which the easiest way, I would say, probably not the most common way, the most easiest way for a last will and testament to be challenged. New York State, in particular, has strict requirements as to the formalities for signing. A failure to observe any formality can render a living last will and testament null and void, right? And however, a will execution supervised by a licensed attorney is presumed to be valid. So that's really good for the executor that's going to be presenting this will to the court. So what exactly do we do in our capacities as trusted state's attorneys? Well, after going back and forth with various drafts and we're ready to execute, we typically have our clients come into the office. We do a little signing ceremony. We bring in two witnesses. They should always be disinterested witnesses.
That's a big one. Don't ever have anyone that is mentioned in the will to be a witness. This is gonna bring a problem.
Exactly. So
especially in New York.
Exactly, because if one of the witnesses in it is interested as a potential beneficiary in the will, then they can't be a witness and also receive something on the will. There's a conflict there. New York presumes there's a conflict of interest in there,
it might
and
be
so
void.
They'll be null and void, and then they might not want to. And
or they're going to receive the less of whatever it's written in the will, or what the less of they would inherit under intestacy rules or whatever it's mentioned in the will. So that's why we always have disinterested witnesses.
Correct, and it's like you just don't want to go there. It's such an easy trap to fall into, but it's also an easy one to avoid. Just have two disinterested witnesses. We usually bring a secretary, paralegal, or another attorney from our office to just come in. Disinterested witness done. Interestingly enough, a lot of states have very different rules to this. For instance, I'm also licensed in Florida, so I do wills and trusts in Florida. Florida actually allows disinterested interested witnesses to for will signing. So Florida is a completely different rule. They don't see a problem with it. But the bottom line is, wherever you're signing a will, regardless, just use disinterested witnesses, right? Just to avoid any complication. So I think we just touched upon this, so I'll just go through this real fast. But the due execution best practices. The first thing I say is that, of course, we're a little biased here, but use an experienced attorney, right? They always know best. Try not to, as much as it's tempting to go, to LegalZoom or something like that. The LegalZoom can't actually be there for you and help you out. But if you're unable to, just some real quick points here. Make sure everyone, witnesses and testator, are in the same room, right? No interruptions. Make sure it's a quiet place. Don't do this at a cocktail party. Don't be like, oh yeah, I have a will to sign, and talk to your friends and say, I'll just bring the will over to the cocktail party we're all going to later on tonight. If you do that, then questions can arise later on. Did they actually understand that? Had they been drinking? Did they really understand what they were signing? Were they signing it as a joke? Were the witnesses understanding what they were signing? Was it what was the conditions? It was a loud place. It was like, you want to do this in a very quiet place. You want to make sure everyone understands the seriousness of this document, right? So have witnesses become acquainted with the testator, and that doesn't mean they have to go out and have lunch or anything like that. We're just talking about basically introducing themselves, like, this is such and such and this such and such. Do you want them to be your witnesses? Yes, great. Testator should describe the document. Again, they'd have to read the full document, just be like, this is my last will and testament, and I'm doing this under my own volition. And again, only use disinterested witnesses. Sorry, Tony.
No, what I was going to mention is also make sure that you're taking that time for the execution of your will, or even if you're bringing someone, make sure that they also have the available time to do that, because it takes time. For example, we just had a signing last week, and it took I think 1 hour and a half, 2 hours. So
things can come up. Absolutely, great point. Things can come up. Usually, if everything's in order, it takes probably no more than an hour, usually about half an hour. But so we go over things. We answer questions. There could be other documents. There could be a typo caught in the last minute that you have to re-sign. So just make sure, if you have whatever witnesses you have, that they have the time in order to do it, right? They don't have to run out the door immediately. And again, the last will and testament, the healthcare proxies, do not sign until the witnesses are there and they're ready to witness. So grounds for will contest: lack of mental capacity. I apologize, I see a typo here now. This is meant to be number 2, but lack of mental capacity. This is sort of like, for the layperson, this is one of the more well-known challenges to our last will and testament. These are the kind of things you see on dramas, on TVs, and things like that. And it's basically what we touched upon. If someone is on their deathbed and they're going out, and then you have the classic where someone takes their hand and scribbles their signature, leaving everything to that person that's helping them sign the will. They don't really understand what they're doing. So that's one classic challenge, right? Believe it or not, it's a very, very difficult burden to meet. It really is. While the proponent of the will, which is typically the executor listed in the will, has the burden of meeting that, the threshold, like we mentioned, is very, very low, right? So if someone wants to come in and they want to challenge that, then they really, really have to show some really concrete circumstances as how the person really lacked the mental capacity. So in this situation, witnesses can be brought in and questioned if anyone decides to challenge the will. This could be the witnesses, could be the physicians, whatever, doctors and other people that surrounded them. And it's must have strong grounds to contest. Like, for instance, the testator did not recognize close family members, believe their estate was worth nothing when worth millions, that kind of stuff, right? And it does have to be concrete, right? Having said that, this is one of the classic cases where it's not like that can really, really tangle up an estate, right? If there was someone that was left out, it's not getting enough, or they think they're not getting so much out of the will, they can get very, very upset and then decide, you know what, I could get more under a copy of a previous will that was revoked by this will, or I could get more under the intestacy rules, right? Might be a child. So you know what, I'm going to just start litigating this. I'm going to throw the kitchen sink at this. I'm going to get an attorney. I'm going to say, and that's when the animosity, the issues start, because then what happens? Attorney's fees have to be paid. Where are attorney's fees going to be paid? From the estate assets. The executor utilizes the estate. It can start draining the estate, right? And that could actually sometimes be someone's objective. They want to drain it to try to force some sort of settlement, right? And so that's why it's so important in order to follow these formalities and make sure there is the due mental capacity, right? And that if need be, you do a video recording, you get certain testimonies from people and all that kind of stuff. So I think we just, sorry, I think we just missed a slide to lead it because there was also one for
Undue
undue
influence.
influence. Yeah, my apologies. There's a slide missing here, but there's another grounds for, and that's what's known as undue influence. I just wanted to touch upon. I'm not sure why it's here. It could be a misordering of the slides, but the third ground, which is undue influence, we'll just touch upon briefly, is basically somewhat goes, it's when there's a person that has it's when a person has control over the testator, the person that makes the will, and it's a vulnerable person, right? So it's typically like when you see an elderly person in their deathbed, and there's a person that's taking care of them, but they don't let them see anyone. They make controlling all their decisions. They're giving so much influence. They're giving so much they're just so controlling that they essentially dictate the terms of the person's last will and testament, that they may not really reflect what the testator's true intent is. And it's really the intent of this undue influence. And that's what undue influence is. Again, it has to have some concrete basis, right? You can't just have motive and a reason for it. You actually have to, if someone decides to challenge it on undue influence, they actually have to provide concrete evidence of and explanations as why, as where the undue influence came from.
Yeah, some of the evidences are like, for example, paying for the attorney to draft the will of the person, the testator, or make sure that they don't see any people from the family. So they need to prove some of this kind of evidence in order to be successful.
Yeah, and again, this typically these kind of challenges usually come up with last will and testaments being signed right at the end of life. Always best to do it ahead of time. Obviously, people want to make changes at the end of life too. That's common and that's acceptable, but it should be properly supervised, right? It shouldn't be done just by people that lack the knowledge of the potential issues that it can face. So having said that, yeah.
One more thing, because we talk about these main grounds, it's very important to mention that it's not anyone that that can contest a will. You have to have standing. You have to be
correct.
An interested party to object to the probate of that will. So
correct.
In some situations, usually it's an economic interest, but in some situations, for example, like a fiduciary that was appointed, let's say an executor that was appointed in a previous will that has been revoked, can object for the appointment of a second executor, but he has to show good cause. So, but usually the problem is the economic interest.
You're right. And so basically, if you were a beneficiary in a previous will that was revoked by the one that's now being presented to the court, or if you're a potential intestate heir under the laws of New York, then you all would essentially have the standing. So not anyone can challenge it, right? Just those specific individuals. So I just wanted to get in here now that we've gone over this, to give you guys some sort of tell you guys an interesting story. This is a case that I learned about in my trust and estates class in law school so many years ago, and I just thought it would be a nice, good example of when things go really, really wrong. Grounds for will contest, undue influence, and I think lack of mental capacity was in there as well. This is the estate of Seward Johnson, right? So, who was Seward Johnson? Seward Johnson was the son of one of the Johnson & Johnson founders, right? Very, very wealthy man, came from a very wealthy background. He was the father of 6 children from 2 marriages, right? So, following his second divorce, he married his chambermaid, a newly arrived Polish immigrant, Barbara Piasecka, in 1971, and she was 42 years his junior. He signed his final last will and testament on April 14th, 1983. At that point, they had been married for more than 10 years now. It's nothing exactly like getting married and immediately dying. And he was leaving, in that will, he left virtually all of his estate to Barbara and nothing to his children. So Seward Johnson then, died probably a little more than a month later, May 23rd, 1984, at the age of 87. The children, of course, not surprisingly, his adult children contested the terms of the will based on his mental capacity and undue influence. They claimed that Barbara, his Polish wife, was physically and emotionally abused to her husband. The estimated fortune that they were fighting about, and this was almost 40 years ago, was $400 million. It's now adjusted for inflation. That would be close to $1 billion. So it was a huge, huge incentive here to fight over this, right? Because obviously if the kids, either there was a will that left more for the kids, which I believe this was the case, but if the will's thrown out, intestacy, the kids are going to get substantially more money than under the intestacy rules than under his latest will. And so, yeah, after 3 highly and very embarrassing publicized legal battles spanning 3 years, parties settled with children, and the children ended up receiving 12% of the fortune, which is a substantial sum of money and well worth it. So very interesting key points here, not key points, sorry, just amusing facts. Both sides claim victory after the fact. Judge and juries actually attended the children's victory party, not Barbara's. If anyone's interested, Barbara actually eventually moved back to Poland with an estimated net worth of 2.7 billion in 2007. She was a very smart lady, very well educated, knew how to handle her money, so she made it grow. She was into philanthropy, involved in many charitable projects, and she passed away in 2013. I think she passed away as the richest woman in Poland at the time. So obviously, look, we're not all heirs of vast fortunes, right? These are the public battles, but it's still what this case kind of reflects is this is what happens when what potentially happens when you have people fighting over your estate at death. Obviously the attorney's fees were paid out of the estate assets. It gets embarrassing because everything that's presented to probate court, to the surrogates court, that's public information, right? So anyone can look it up. Lots of skeletons were coming out of the closet. People are trying to get the upper hand, so they accuse each other of embarrassing things. And
Chris, I think this is the typical example of a case in which the testator simply wanted to disinherit his kids and left everything to the wife, which you can do here in New York. You cannot, maybe you cannot do in some other countries, like my country in Brazil, you have forced heirship, but here you can definitely, the only person you could not disinherit is your wife, and we're going to talk about that later on, but that's the typical case. So
yeah. So, just a quick picture here, on the left, Seward Johnson and Barbara, 1979. There's the happy couple there. And then on the right, Barbara Piazzetta Johnson, just in 1986, I think right after the conclusion of the case. There it is, the grieving widow. She's, quite two different circumstances there. All right, so we're going a little over time here, so I just want to go through here real fast. So one thing I also wanted to mention is what's called the spousal right of election. So yeah, it's not that kind of election. So just ignore that picture. I just thought it was funny, but spouses. So Talita actually just made a point about how you can actually disinherit your children in New York and most states here in the United States. But the one person that can really, really never be disinherited is a spouse. A spouse in New York cannot be completely disinherited. Spousal right of election in New York allows the spouse to elect against the estate, right? Against any will that's completely disinherits her or gives her very, very little. And the spouse can either take the greater of $50,000 or a third of the deceased spouse's net augmented estate. So if the estate is worth $50K, the spouse is getting everything, regardless if the decedent decided to leave it to his son, a friend, or whatever. Trying to avoid what we call probate, right, which is leaving things in a will for it to be challenged in court, won't necessarily help here in New York. The augmented estate that we talk about when we're dealing with spousal right of election includes gifts made within a year of death and transfers to revocable trust, joint accounts for third parties, things like ITF, payable on death accounts. Each state has its own different rule, right? Interestingly enough, right next door to us in Connecticut, Connecticut actually does have a spousal election. and it exists, but it's essentially worthless. It's just toothless because it only applies to assets passing by a last will and testament presented to the court. So basically what a spouse can do that wants to disinherit his wife, create a trust, throw everything into the trust, essentially leaving nothing titled in their own name at their death, and then their spouse has no recourse, right? And before any New York domiciliaries and people here that are residents in New York think about this, you need to be living in Connecticut. It's not going to work just to say, I hereby proclaim that the laws of Connecticut are going to essentially control my estate plan or my will or anything like that. A New York judge would just throw that out as against public policy in New York. So let's go into some potential planning strategies. We just talked about all the issues that may come up. So what are some helpful tips that we can see in order to try to mitigate or avoid any sort of potential disaster here? So planning strategies, other considerations. This is really planning strategy in regards to spousal right of election, right? So the first thing I always like to say is, and of course you've got the cute kitties there, you always want to be like, communication is key. You want to be just as cuddly and friendly, hopefully, as these two kitties. And communication is key. Spouses should be on the same page regarding an estate plan. And because obviously if you're on the same page, you're way less likely to contest and elect against it, right? One thing that a spouse could potentially do, who doesn't want to leave everything to their other spouses, calculate the spouse's potential elective share and ensure that at least that such amount is left for the spouse. Or you could put something along the lines of, look, if it's greater than $50,000, then a third goes to the spouse outright. You can make gifts throughout life. You can make gifts. If the gift is made a year before death, right? So you can't make any deathbed gifts. So those won't work. But if it's made more than a year, it doesn't factor into the spousal elective share. So over your time, you can potentially, if you've got, for instance, kids in a second marriage, you can make outright gifts to them during your lifetime. As long as those gifts were more than a year before your death, then they're not going to factor into the spousal elective share, because any gifts made within a year can actually be clawed back by the court. Gifts can also include a transfer to an irrevocable trust during the lifetime, which decedent had no power to revoke, benefit, or modify the trust arrangement, right? So you, again, typically happens in second marriages. Someone wants to leave something to the kids and they want to do it in their lifetime. They can create an irrevocable trust, just as long as that gift is made within more than a year after death. So it's good to try to plan this stuff out well ahead of time, and then that could work too and not be factored in the spousal elective share. Another way to do it is, people really don't like it too much, but prenup, postnups. People tend to think prenups and postnups are really for divorce cases, to determine maintenance and all that kind of stuff, and who gets things if they break up. It is that. But another important planning strategy for pre and postnups, and we do them as well as trust and estates attorney, is for a spouse to waive their elective share in that contract, right? So we always put a waiver of the spousal elective share in any prenup that we do, right? And any postnup that we do as well. And that can be contracted away, right? And then the parties are free to make their decision. They can completely disinherit the other spouse. Now, of course, that can be a little tricky, right? So not a lot of people like to do that. They think it's awkward. But pre and postnups can be very flexible documents. So you say, okay, well, I waive my right of, we waive each other's right of election, but I leave you X amount of money, right? And then that will be enforceable against both spouses, right? It's going to be essentially a contract. However, don't do a prenup. Don't try it at home. Don't try a prenup or postnup at home. The documents are, judges are always looking for ways in which to knock down a pre or postnup. So there's some formalities that have to be followed. There has to be complete disclosure of assets. There's got to be no potential for pressure against one party. So it's got to be carefully done, preferably both parties represented by counsel. So just look, there's no unfairness going on. So if you do consider this, really look to getting counsel to assist you with that, to make sure that it's not going to be considered invalid in the future. And finally, one, look, I don't want to,
great.
just
one thing for the prenup that I was going to say is also make sure that, you know, this document is signed like 6 months prior marriage, not very close to the marriage. So it might come, you know.
Yeah, I mean, I think I agree. It's just to show lack of pressure, but at the same
Exactly.
time, I don't think it needs to be 6 months. I mean, I think it could be
earlier, before arrangements.
Yeah, if necessary, it can be, you know, preferably a couple of months. It could be even a couple of weeks, but the key is it really is a case by case basis, right? Some people want it get married sooner than later, so it does depend. But it's important for it to be supervised properly.
Yeah.
And the very last point as well is, look, if you're looking to completely disinherit your spouse, you guys are, you know, not getting along, you just don't like them. Well, first, you know, look, consider marriage counseling. You know, a lawyer is not the place to go for marriage counseling and for relationship advice. God forbid someone asks me for relationship advice; they're asking the wrong person. But you know, consider, you know, really giving it some good thought. Look, if you're looking to completely disinherit your spouse, it's like, is it worth staying with them? You know, get a divorce. A divorced spouse has no rights, has no spousal election. Of course, that has to be balanced with the potential spouse's potential right to marital assets, right to division of marital assets. That could actually be worse. They could actually stand to get more in a divorce. So that's always a careful factor to consider. If you're really considering getting a divorce, then it's typically early on in the marriage where the other spouse really isn't entitled to much. There really aren't many marital assets. And so typically both spouses would be able to walk away with whatever they own. For people that are married for many, many more years, that gets a little more difficult. So, but it's also a misunderstanding a lot of people have, that as soon as they get married, then their spouse is all of a sudden entitled to like half of what they own. That's not true. I don't want to go into it. It's kind of outside the scope of this presentation. We're not divorce attorneys, but you know, it's like it takes time for a spouse to be able to claim certain rights to what we call marital assets. Those have to be built up over time, right? So if you get married, and within a year you're thinking, oh my God, what have I done? This was the worst decision of my life, and you have a substantial assets, then it's best to get if you're really want to get divorced, it's better to do it sooner than later. And so the last couple of pages is basically planning considerations with regard to anyone other than your spouse. So anyone other than your spouse is entitled to nothing. All right, they're under New York law, under virtually every state. You can disinherit anyone. You can disinherit your kids, other family members, right? Only the spouse has the right to a certain inheritance. So the best way to do it is to try with these kind of people. If you think you're going to have a problematic child that might try to really gum things up in probate court, is with the last will and testament, and make those challenges like the kids of Seward Johnson did. It's considered what we call testamentary substitutes to avoid probate. So it could be what we call an interest for payable on death accounts, right? You have bank accounts in which you can either have joint accounts, or you can actually have payable on death designations, and those function outside of probate. You can't challenge that in surrogate's court, right? Assuming that the designation was valid, and those are pretty easy to do. The joint tenancy of rights survivorship. If you have a house, for instance, and you want it to go directly to someone, don't let it go through your estate through probate. Instead, consider joint tenancy of rights of survivorship. Again, do this with a lawyer, because if the person that you're putting onto the title is not your spouse, there can be potential gift tax ramifications. And of course, once you put someone onto the deed, they are now an owner of that property. If you want to take them off later on, you're going to have to get the consent to be taken off. So that can raise challenges. But if you have the right of survivorship language in there, or if it's your spouse title with your spouse, then that avoids probate. So the surrogate's court won't have any jurisdiction over that. I'm sorry, hang on a second. Living trusts. We do a lot of living trusts. We love living trusts, both revocable and irrevocable. Again, that works outside of probate. Anything titled in the name of a living trust during your lifetime, and you could be the settlor, trustee, and beneficiary during your lifetime, just so long you have remainder beneficiaries in there to take after you pass away with successor trustees. As long as assets are titled in the trust, those avoid probate too. The court would have no jurisdiction there. And last but not least, life insurance policies, valid beneficiary designations, another way. And interestingly enough, by the way, life insurance policies do not factor into the spousal election share. So you can actually purchase a policy, right? $1 million policy, name whoever you want to name in it, and not even your spouse will be able to challenge that.
Also, it's a very good way to provide like liquidity. I mean, especially people that inherit like real estate, so they need to pay bills, they need to pay, to keep paying like the bills to maintain the property. So definitely a life insurance, it's a good instrument for estate planning.
Absolutely, yeah. Depending on your age, of course, otherwise it gets a little pricey right at the end of your life. And finally, what we want to mention as well is what's known as in New York interorum no contest clauses. This can also be a really, really effective way if things are going to pass through your will. If you think there's going to be everyone, first of all, should have a will, right? Because if there's anything titled that's not titled into a trust, for instance, you want to make sure that that actually goes to where you want it to go, even to the trust. And so if a person thinks that there's going to be some problems, like in Seward Johnson's case, where there's potential for the children to contest the will, then you put a no contest clause in there. Some states don't permit them, but New York does. For instance, I do wills in Florida, trusts in Florida. Florida, they're void. Florida doesn't recognize no contest clauses. It's invalid there. New York, it actually is valid. So what is a no contest clause? You basically put into the terms of the will, if you challenge this will and you lose, you get nothing, right? So it could be a real key incentive there for someone that just really wants to go out of spite and try to force a settlement and try to just essentially run up bills against the estate. This could be really, it's a very simple clause to put in there, but it can be very, very powerful, very, very effective. Anyone that contests the terms of the will of trust and loses, they would receive nothing, right? And obviously the best strategy in this case with potential troublesome heir, family member, or what have you, is to leave them a token amount in the last will and testament, right? Which they will lose if they contest the terms. And because then obviously if you leave them nothing, you could put a no contest clause in it, but they have nothing to lose to contest it. So, depending on the assets, obviously it's on a case by case basis. You want to put a decent amount in there that they would really, really be hesitant to walk away from, right? You can either get this now, or you can risk a contest, which will be really difficult for you. The grounds are difficult to prove, and then you get nothing there, all right? And finally, obligatory disclaimer. Look, it's just a presentation, just for informational purposes, blah, blah, blah. We're not your attorneys until you hire us. We're more than happy for you to hire us, but you need to come to us first. This is just for your own information, as is. No representations that this content is error-free. Reuse at your own risk. For further information, get in touch with us. And that's it. Thank you for sticking with us through this presentation. If anyone has any questions now, then I'll be happy to answer them. So we have one open question here from Sophia. Question: as a lender, if company borrower owned by 2 or 3 people and one person, partner, shareholder, passed away, then what document or information to be secure the deceased person should transfer its remaining partners to shareholder? Sophia, so it's a good question. When you have a company, the first thing that you need to look at is, let's take an example then, because I think you've got, a company partnerships. You have LLCs, which have members, you have corporations that have shareholders, and you have partnerships like LPs that have partner interests, right? So they all function essentially the same. Let's say, for instance, you have 3 partners, right? They just simplify, each own a third either a third of the shares own a third of a partnership interest or a third of a membership in an LLC. So there's two ways in which it can be passed. Each entity should have, like an LLC should have an operating agreement, right? Which is essentially like a sort of like a partnership agreement between the members. A partnership should have a partnership agreement, and a corporation should have what's called bylaws, right? And those essentially have the rules of the company. There's a couple of ways in which you can decide who gets those shares. Those documents, the bylaws, the partnership agreement, or the operating agreement, could actually have a term, what we call a transfer on death, right? Just like you have a bank account. Actually, New York does allow that for security. You can actually put in there, oh, on the death of such person, this person's going to inherit it. It's not terribly common to see that, right? Because if you want to modify that and you have other partners, then to be able to modify that, you're going to have to, you're going to have to get majority consent. So what people tend to do is they tend to take their shares and they tend to either put it in a living trust, right, with the terms already in there, like a revocable trust in which they're the beneficiaries during their lifetime, and or they put it in the terms in the will, right, who specifically gets those shares, right? So you have to look at, so let's say, for instance, they die without a will or a trust, and they hold, a third of the shares of a company or a third of the partnership interest. Then that is considered property. That's considered intangible personal property. It's going to go per the intestacy rules of whatever their domicile is. If their domicile is in New York, it'll go under New York rules. If their domicile is Brazil, for instance, it'll go under the intestacy laws of Brazil. And so, yeah, it can get a little complicated depending who the partners are. Another factor is that most of these agreements, they don't allow, a good, well-drafted agreement only allows whoever inherits to have economic interest in the economic benefits or dividends. They don't allow them to manage the company, obviously, because the partners, shareholders, they don't want those people to some unknown individual to come in and have a say of what the company is. And sometimes they even have buyout provisions, right? So if someone dies, then the partners typically have either some right of first refusal or a buyout for that interest, right? That may be held by an estate, may be held by a trust, may be held by an heir, what have you not. Okay, so hopefully I answered that to your satisfaction. But yeah, it can get confusing. So I've got another question here from Aaron. What if you get married but file separately? What if you get married but file separately and each spouse owns a home in a different state, okay, New York and Connecticut, and each spouse claims their primary residence in different states? What laws would apply? Good question, Aaron. So it would depend on what, so I think you might have heard the term that we're just throwing around here called domicile. So domicile is an interesting term. It's what we call a subjective term. It's really, you look at the facts of the case, you look at a lot of different factors where so yeah, you could say, for instance, oh, I live in Connecticut, right? If you want to completely disinherit your spouse, oh, I'm domiciled in Connecticut. But that could be challenged because domicile is a subjective, right? So it's really, okay, well, where were they domiciled? Where do you think they were considered domiciled? It's not enough to write on a piece of paper, they just declare it. You have to look at the facts involved in the circumstance, right? So where was the person spending most of their time, right? You could say, oh, I'm domiciled in Connecticut, but if you're spending year round in New York, you're not really domiciled in Connecticut, are you? Where's your principal residence? Where is it that you actually live? You can have two houses, but most people tend to, unless you're like Jeff Bezos flying all around the world, you tend to spend your time in one particular residence. Where are you working? Where's your church or synagogue? Who are your accountants? Where are you filing your income tax returns? These are all key questions. So yeah, it's not just enough to declare it. You actually, there has to be substance to your domicile, right? So, and actually this question comes up a lot when we're dealing with clients of ours that tend to be snowbirds, right? They live in New York and but they decide to move to Florida. Florida has no income taxes, has no estate taxes. That's why people love it down there. And New York State is very, very strict on domicile. They keep tabs on these things. They really do. People don't understand it. They have a whole department dedicated to determining who, people going back and forth, what their real domicile is and whether Florida is really their domicile. So if you really want to change your domicile, you should really, really change it. Spend time there. Don't spend more time in, for instance, in New York than you do in Connecticut or Florida. Title your cars to Florida. Hey, change your associations. Show that your true intent, register, vote right in Florida. Whatever you can, get a driver's license, spend time there. Have your family visit you there if possible. You can visit your family in New York too, but yeah. So yeah, it's and if you file taxes separately, I just saw your thing. So yeah, file taxes separately. Well, where do you file it, right? Because if you file your tax separately, that may be so, but where are you filing, right? So let's say, for instance, you declare your domicile is in first of all, that's just one factor that's not going to be dispositive, right, of domicile. But second of all, let's say, for instance, you're really living and working in New York, right? You live in Westchester County and you commute into the city. And you probably spend almost no time. You may have a house in Connecticut, but you just go there for an occasional weekend or something like that. So the only tax return you're really going to be filing is a New York State income tax, right? If you want to, you could file an income tax return for Connecticut, but you're going to be under no obligation, and you could end up paying more than you really need to, right? So most people tend not to do that. There's usually other ways in which you could establish domicile better than filing tax returns. But obviously, if you're claiming domicile in Connecticut, but you're really here in New York all the time, and you only file in Connecticut and not in New York, New York's going to have something to say for that. But even if your employer is outside, let's say, for instance, you're in Westchester County and you commute to Connecticut, right, to work, but you live year round, really live year round in New York, you're still going to have to file tax returns in New York as well. Otherwise, they're going to come after you for back taxes, right? So hopefully, sorry, it was a little bit of a long-winded response there. I like to listen to myself talk because I'm an attorney, but hopefully I was able to answer that question for you. And let's see if we have any more. I don't think we have any more questions. And so I'll give it 2 more seconds. And but again, if you have any more questions, feel free to email us. We'll be more than happy to answer them after the presentation. And just to let you know, we are recording this. So if you want to go back and hear anything again, you're more than welcome to. And we're also going to send a copy of this presentation to everyone that registered before. Oliver will be sending a PDF version of this. All right, so I think that's it. No more questions. So we just want to thank you, everyone here today, for joining us. Alex, can we download the slides? Alex, Oliver, would they be able to download the slides? Do we have those online, or do we only email them out?
Yeah, we're going to email them out. Well, no, we're going to send them in the email, but they will be able to download the presentation as a PowerPoint, as a PDF.
Okay, great. Is it okay? All right. So okay, great. So yeah, thank you, everyone, and thank you for the questions, and thank you for your participation. And we look forward to seeing you on our next webinar. All right, take care.